Well, considering that the entity is Bank of America, they do not hold, in my eyes, and I have uncovered that they do not hold the power to foreclose on this and act as the beneficiary in this matter.
Okay, I'm at this point, without delving into the different aspects of fraud, could you give me a round number, preferably an exact number, of how many fraudulent acts did you discover concerning the deed of trust and the recording of the fraudulent deed of trust?
There's 3 acts of fraudulent recordings on this particular case. And it's also troubling to know that Recon Trust is a subsidiary of Bank of America. They are regulated by the Office of Comptroller of the Currency, and it looks to me like they have perpetrated a fraud basically by filing on the same date, same time, 3 different documents.
Okay, in your expert opinion, how many aspects of fraud must I establish for this court to invalidate the defendant's standing?
1.
Okay, is 1 more than 3?
1 is more than 3.
Okay. So, Your Honor, I reserve the right to recall and what? Oh, did I say that? It was working at the bar last night.
My coffee's cold, too.
Yeah, we got to get some more coffee in here, people. We're going to be taking a break quick. We'll get some more in there. So is 3 more than 1?
Yes.
Okay. Glad we got that cleared up. Your Honor, we've already established the fraud. Really, the court has no choice but to rule in favor of the plaintiff. But I'll go ahead, just for time constraints. I'm going to reserve the right to redirect. We'll let the defense go ahead, unless the defense chooses to vitiate their future criminal liability in this issue by accepting the move for default, and that'll be all for now.
John, before you go do that, can you just do a move? What would be your move? Because you just established the fraud.
Could you just, I know you're going to go into another phase. What would be your motion to the court right now?
I would motion for either declaratory judgment, summary judgment, default judgment in favor of the plaintiff. I would just move this court really to render a decision based on the fraud already discovered. The judge isn't going to want to go much farther than this. The judge isn't, because now he's looking at making a jurisprudence, decide some kind of judicial decision that's going to screw over the people that are bribing him. They don't like to do that. So they may perhaps, he may, and I've seen this not in a case like this, where the judge just says, hey, why don't you guys go talk? Okay, and that can happen. My whole concept in this is getting the pleadings to where the judge just says, why don't you guys talk and get this the hell out of my court? Okay, now I would, at this point, because you have the right to redirect. In other words, she's going to talk to the witness, and you can bring the witness back up. I want to see where they're going to go. I've already established the fraud. If I got to delve deep into it, blah, 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 then we can. And we can do that in redirect. I just want to see what's the tricks up her sleeve. Yes. By just walking away right now. Okay.
Ready?
Yep.
Mr. McCaffrey, what level of school did you have?
You're supposed to say there has nothing to do with this.
Your Honor, objection. If she's attempting to berate instead of impeach my witness, I must object.
Your Honor, I have to establish whether or not this witness is qualified to make all these statements, and I
It's-
have the right to do
Ms.
Your
that.
Honor,
Quintel.
there is no licensing or educational requirement in this situation. She does not have the right to ask that question.
Ms. Cantrell, we have an expert witness. It's already been established.
All right. Thank you, Your Honor. Mr. McCaffrey, have you ever purchased property before?
I'm sorry, could you please repeat the question?
Sure. Have you ever purchased a property
Your Honor,
before?
objection, okay? That has nothing to do, what he does in his personal life doesn't have anything to do with this.
It
We are-
does, because it goes to motive.
Your Honor,
Okay,
is she questioning the motive of an expert witness in this court? Are you
Would
questioning?
you allow me the opportunity to state where I'm going with this before you?
Mr.
No,
Mr.
Your
Stewart,
Honor,
Mr.
is she
Stewart.
questioning the motive of an expert witness in court?
You must have misspoke. I don't think I heard you correctly. I'll give you another chance to rephrase.
What I'd like to know is whether or not this witness has ever obtained a loan of his own
Yes, I
for a
have.
property.
I have.
I'm going to allow that at this point. I'm not going to entertain much more of this.
Yeah, where the hell didn't she just say that, Your Honor?
Because I did. I said, have you ever purchased a property? So you've obtained a loan. And at the time that you obtained a loan, I'm assuming you used a bank?
I did.
Okay.
Your Honor, objection, okay? There is no relevance to her line of
Do
questioning.
you have a point to?
I would just like to establish whether or not this witness might have a bias because he himself has a property purchased with a loan, and therefore what he's trying to get on and for the record here may benefit himself.
Your Honor, he's an expert witness.
Ms.
There-
Quintel, we're not going to make that connection here today. He's an expert witness. Please rephrase the question.
Your Honor, if the defense has no questions or no evidence to dispute their criminal acts, they need to just stop asking questions.
Your Honor, I'd
Either
like
ask
to move on to
questions.
my next question, if he'll shut up.
Excuse me, Mr. Stewart. I've got this. Do you have any more questions for the witness?
Yes, I do. Thank you, Your Honor. Mr. McCaffrey, is it your contention that an assignment deed of trust, substitution of trustee, and a notice of sale cannot be signed on the same day?
That's correct.
Wait a second. I thought they could.
No, I'm just kidding.
Oh, okay.
They can, yes,
They can be signed on the same day.
absolutely.
All right. I direct you to look at those documents again and state on and for the record what date they were all three signed on.
What's interesting about these documents is,
Your Honor, I just wanted that one question answered. He
Objection,
sounds
Your
like he's
Honor.
going into
The
other-
expert witness needs to testify to the truth, the whole truth, and nothing but the truth. She's trying to restrict his testimony. She can't do that. Please let him answer the question.
Yes, please continue.
the date that they were all signed is February 6th, 2010.
Okay, so it would be your contention that February 6, 2010, they were all signed, and there's nothing wrong with signing those three documents on that same day.
No, there is nothing wrong with signing all three of these documents on the same day.
No further questions.
Mr. Stewart, would you like
Yeah.
to?
Yes, Your Honor. I do want to state on and for the record that the defendants did not establish any prima facie matter to rebut all of the accusations. So I really move
You know,
for a ruling in favor of plaintiff.
I'm going to call a recess at this time, and I would like the two of you to go out in the hallway and get this matter resolved and come back to my desk.
Really, guys, the point being, it's probably not going to happen like that, as you'll see when I get over there. There's a thin line that they don't want to cross, okay? And they're much better at it than most of us are because they're used to lying on a constant basis. And it's not always just lying, it's obfuscating the facts and moving things around and twisting things. What they've got to do, all this evidence, okay, remember in the beginning I told you, listen, I don't want to deal with this shit with anybody if they don't do the forensic examinations. Because that's where everything is. What Bill does, what Horner does, you get all this evidence and everything they did is fraud. Now, if you just want to come to court and have an argument, go get married. It's just as effective. You can't pull this shit off in court without evidence. Okay, you just can't. So now that all this evidence is in there, they've got to somehow rebut it. Now, we've seen enough cases to where they kind of walk around the rebuttals of it. What you got to be able to do is catch how they're not really rebutting it, just making it like they sound like rebutting it. You got it? That's the tricky part. And they're very good at it. They're snakes. That's what they do. They're making a lot of money to make it sound like they're saying something when they're not really committing to that statement. So we're going to kind of reverse things. Cindy's now going to be representing herself, and I'll be representing the banks. We'll do this for about, how much time do you guys need to get your rooms taken care of, get your stuff down here? Because we're not breaking for lunch. Oh, is everybody done? Everybody's gotten their rooms taken care of and their stuff out of them because of checkout stuff? Okay, then I'll ask again. How much time do you guys need? Because you got to be out of your rooms at 1, right? So what time do we want to stop so that you guys can do that? 12:30? Everybody say 12:30 is good? 12:30 is good. Yeah. Okay, so that gives us 30 minutes. So Cindy, you're going to go over and be plaintiff. I'll be back here.
You have a copy of the note, right?
Yeah.
I've been waiting for this all week.
Have you really? You don't get out much. I was waiting for last night all week. We had more fun. At least that's what I heard. Don't remember any of it.
We gonna move with opening statements, or are we just gonna go ahead?
No,
with
I don't.
The...
No. The opening statements you're gonna write up. We'll have some stuff out there that you can kind of cut and paste. You're not gonna get away with much objections during opening statement. Do you see them get away with many objections during opening statements?
No, the bottom line is the judge lets each party have an opening statement. The one factor that you have to pay close attention to if you're representing yourself in opening statements is be concise, slow, so the court reporter can take the notes, because you can speak a lot faster than a court reporter. And so you try not to have any interruptions from the judge, because the court reporter will raise her hand up and say, hey, listen, he's going too fast. So you want to be slow, concise, and to the point.
Yes, and there is an allowance for objections. Judges don't like it. Most attorneys won't do it. If you do it, they'll do it. I do it on the mere fact there's certain things I don't want on the record. I at least want an objection if it does wind up on the record. But don't get real pushy with it, okay, because you'll piss off the judge.
Right.
So we'll skip the opening. Now, Cindy's going to question Bill on what she wants to get in the record. Remember, when you close that interview with the witness, you always want to reserve the right to redirect. You want to be able to bring the witness back up. If you don't reserve that right, you still really have that right, but the judge will say, no, you didn't reserve that right. You're not going to get to do it. And you're going to want to bring him back up, okay? Because they're going to do something funky. And you have a legal pad right there and be ready to write down. You got to listen, but you got to be able to write too, because funky stuff is going to happen, and you want to undo that. Okay, you ready?
Yeah, I
What?
think so.
Oh, hold on. What? Oh. You got turned on.
So at what point do you reserve that right to bring the witness back up?
Oh, well, as soon as you're done questioning him, and just say reserve the right to bring him back up. Anything like that.
John, just real quick on the pursuant to what is the note and the deed have to stay together?